Welcome everybody to Sealing and Expungement Law. Thank you for registering and showing up today. We've got a full house, which we're excited about. For those of you who have never been here before, I'm Angela Baldry, the director of the library. Charlene Reeves works at the library as well. Couple housekeeping items. If you have not given me your Supreme Court number up here, please do that before you leave so I can get you 1 credit of CLE credit. If you are a paralegal and would like a certificate, just put your email address in that box and I'll email you a certificate after this is over. Handouts and evaluation forms are also up here. Pens and bookmarks, help yourself. If you want to just leave the evaluation sheets on the table or on your chair, we will collect them at the end. The flyers up on the bookcase are the rest of the programs we have scheduled through June of this year. If you haven't already seen them, take one. You can stop at the circulation desk and sign up for any class that you would like to, and we'll have July through December later in the calendar year. Happy to introduce Robert and Tori from the Franklin County Self-Help Municipal Court Self-Help Center. They're going to be talking about the new laws that are affecting sealing and expungement.
Thank you.
Thanks.
Thank you everyone for coming out. We are really excited to have a packed house here today. As Angela said, my name is Robert Southers. This is Tori Edwards. We're the 2 attorneys over at the Self-Help Resource Center next door in 369 South High at the Municipal Court. 375. We're in 369 now. I'm sorry. So to get started, I wanted to give just a little bit of background of what the Self-Help Center is and why it is that we exist. So starting in March of 2015, the Supreme Court came out with a Task Force on Access to Justice report and found that Ohio really lagged behind other states in access to justice. Basically found that almost no one could afford an attorney, that because of the recession, legal aid funding had really been cut. And due to that, there were people that were facing all kinds of really dire legal issues with no access to any resources at all. As part of that, we were one of the ideas suggested in that recommendation as a way to address that issue. So we were originally created by the Columbus Bar Association New Lawyers section in response to that Ohio Supreme Court report. And especially once we get into record sealing law, please don't hesitate to interrupt me. Don't hesitate to interrupt Tori. If you have questions at any point, stop us and let us know. So when we were created with a 3-pronged mission. The first, as I was talking about, being to increase access to justice. Just the belief that if you can't afford an attorney, you shouldn't have absolutely no access to the court system. You should at least have some assistance throughout the process. The second part of that to be improving court filings and generally making court run more efficiently. What was happening, especially in municipal court, is people would file like a crumpled up napkin and say that that was their pro se filing. And that takes the clerk's office hours, if not days, to figure out what that napkin's supposed to be, what kind of motion that is, what exactly they want to do with that napkin that they've given. And instead now, if someone comes in and wants to file a napkin, they can say, why don't you go talk to the Self-Help Center, get some additional assistance, and then come back and file something that might be a little more better for both you and us than just that napkin that you got next door. Finally, we want to provide a positive point of contact between the courthouse and the community. The goal of that being no one's having a great day when they're coming to court. There's all kinds of research about the fact that the community just doesn't trust lawyers or the court itself, and that means that people don't come into the court to solve their problems. So if we can be at least one place that people are getting that positive interaction, we're helping to build trust, we're helping to make sure the community understands everything that the court and attorneys in general can do to help people. We're making the community stronger. We're helping to build that trust that otherwise wouldn't be there. So to talk a little bit about what we do offer informational materials as well as access to legal resources such as books, forms, things like that. And we do allow people to do legal research as well. We have public computers. We can guide people, we can give people all their options, but we cannot give them legal advice. Because we're related to the court can't take a side on a case, and because of that, we cannot give people advice. One way we like to explain that to people is we give people options counseling. So I can tell you all of the array of options you might want to take. Here's the forms you could do to do those options. I can't tell you what words to put on any of those forms, and I cannot tell you which of those forms or which of those options is your best. If that's something you want to do, that's when we refer out to the Bar Association to hire an attorney or to talk to legal aid. We do provide services in only civil cases, record sealing being a quasi-civil action. So you can see the main areas that we serve here. Sealing and expungement, as we're going to talk about today. Our largest area being landlord-tenant law. We assist both landlords and tenants throughout the process of evictions, escrows, other disputes that might come up in that agreement. General division claims, so $15,000 and less. Small claims, $6,000 and less. And then consumer debt collection, where someone's run up a big credit card bill or otherwise has a debt that they're trying to be collected on. We help with a lot of other things as well. Obviously, with where we're located, being right near the entrance of the municipal court, we get questions of just where's the bathroom, those types of questions that people just don't know if they're not here every day. But legal-wise, those are the main things we cover. So talking a little bit about how we can better serve you or the people that you serve every day. I know everyone here's from a wide variety of places, a wide variety of organizations. We do, as I said before, provide legal and non-legal resources. That being, one member that's on our staff is a social worker. So for example, someone who's not eligible to seal their record, their next obvious question is, well, how am I going to get a job with this thing on my record? So our social worker works on building lists and finding places that will either hire people or people can go and get resources to help them find a job even if they're not eligible, or to find housing if they have an eviction, or the non-legal issues that come up as part of a legal case. So that's one way that we can help in addition to just the legal services. We do, as we're doing here today, present to staff and community members. If you work with a large office and not all of them are attorneys, we're happy to come in and give a higher level overview, not getting into the weeds as much about something like record sealing or landlord-tenant law or anything else we do, as a way to help educate people about what their rights are, about what is available for themselves or for the people that you may serve in your organizations. We attend various community events, festivals, places like that we can get out in the community, being that part of the providing a positive interaction with the court and the community. And then we partner with other organizations for things like, for example, this spring, we're offering a driver's license reinstatement clinic to help people get their licenses back. That's going to be April 4th, 5th, and 6th. If anyone's interested in that, I'm happy to talk about it afterwards. Apologize for the shameless plug. But that is a partnership with Ohio Legal Assistance Foundation, Legal Aid, the Clerk's Office, and a variety of other organizations so that we can all work together and provide people services at that event as well. So now to get what we actually were here to talk about today, I want to start with expungement. And people use the word sealing and expungement as if they're synonymous, but they're not. That's one of the biggest issues we see, so that's one of the first things we wanted to address. We often see people come into our office and say, I want to expunge my record. When we tell them, okay, you're eligible to seal this, they say, no, I want to expunge. And then there's a disappointment of feeling like they were told they could do one thing, and then once they find out what it is, they feel like they were told something incorrect. So as you can see here, expungement, the way we explain it is, it's like you take the record, shred it, burn it, bury it under the ground. It's gone forever. No one can ever see it. But because that's such an extreme way of getting rid of a record, it is limited to only a few circumstances, which I'll get into in a minute. Convictions as a time that you were a victim of human trafficking, convictions from juvenile court, and then convictions for a very specific subset of gun crimes. Record sealing is everything else, so that's what we'll spend most of our time today. Record sealing is like it being locked in a filing cabinet, only certain people have access to it. Police obviously still have record access to it, the prosecutor does, the court does in certain circumstances, and it is available to more people than expungement would, but you do have to meet the eligibility requirements. So to start with victims of human trafficking, late last year, the Senate and then the governor signed SB 4, which made some pretty large changes to sealing as it's related to human trafficking. Human trafficking not just being kind of what you see in the movies of someone got kidnapped and forced into something. It can be using an abusive relationship to force someone to engage in solicitation or prostitution. It can be using someone's addiction against them as a way to say, I'm going to take this drug away from you if you don't go out and sell yourself on the corner. It is a more it is a more serious issue than what people realize. Yeah, I'm sorry.
Does that include like human trafficking for working relationships as well as like sexual relationships?
Generally, it will. When it comes time for them to expunge their record, they need to show to the judge how it was that they were a victim and be able to explain that, which is often the most difficult part of that application, but I will get to that in a minute. So the first part of SB4 was that it really encouraged intervention in lieu of conviction, things like the municipal court's catch court, as a way to say, let's get you help instead of just putting you in jail for this issue. Because the understanding is that if you're a victim of human trafficking, you weren't necessarily doing this because you wanted to commit this crime, that because of that, it's because of other issues that are outside of your control. And then the other part was really expanding what could be expunged. So prior to this change, you could only expunge your record if your charge was a solicitation, prostitution, or loitering. Anything else could not be expunged, even if it was related to your time. A common one we see there is drug offenses. So possession, use, things like that, because a lot of times that is the way that people are forced into human trafficking. Now, with the new law with SB4, anything related to your time as a victim of human trafficking, you can get expunged. That does put more of an onus on the victim to show how. For example, we had someone the other day that had a jaywalking that she wanted to try and expunge. And she explained, I know she explained to Tori, how that jaywalking was related to something that was a common practice in victims of human trafficking, of a way that they would stop cars, was that it? Or something, and she wanted to make the argument that that jaywalking ticket, which is usually something that couldn't be sealed, should be expunged. So anything at all that can be argued as related to your time can now be put on that application to expunge your record. That's most of what I just talked about. The other part was that any dismissed charges could not be put on an expungement application. Now dismissed charges can be put on there as well. Generally, to apply for expungement, you do need at least one conviction for either loitering, solicitation, or prostitution still. But that one sign is usually enough to at least flag it and be an issue that they could at least make the argument for the judge. It is a very difficult thing, both emotionally and legally, to accomplish. It requires that victim to relive all of the trauma of being a victim of human trafficking. So it is something that we help with, and it just takes a lot of patience and time to really sit with someone and help them work out all of the different issues of their past. One common thing we see with this, which could be a whole other CLE on its own, is just that victims don't always recognize that they were victims. So it sometimes just takes some time on our part to explain what that means under the law, explain that, yeah, you don't feel like a victim, but under the law, what you're telling me is you were actually a victim. Juvenile convictions are pretty straightforward, so I'm going to go through these pretty quick. Juveniles, if they were charged with their crimes under 18 and tried in juvenile court, can apply to expunge their records as well. We usually recommend that they go over to the juvenile court for that, because finding those records is difficult unless they're over at the juvenile court. Finally, certain gun crimes can also be expunged. This is rarely seen anymore. Most people that were eligible for this have done it by this point. Prior to September 30th, 2011, there were stricter rules in Ohio for when you had to tell an officer if you had a gun in the car with you. When they changed that law to make it less strict for when you had to tell the officer about that firearm in your vehicle, they said anyone convicted under the old law should be allowed to get that expunged. We're just going to get rid of that. We don't agree with that old law. We do have forms for that in our office. We do help people with that when it comes in. But since I started working at the center, I think I've seen one of these. Like I said, most people that had those old ones, since this was back in 2011, have done this by this point. So now I'm going to turn it over to Tori. She's going to talk some about sealing records.
Hi, everybody. So first I'm going to go through kind of the steps you need to go through when you're deciding whether someone is eligible to seal their record, because it's so complicated and there are so many statutes that go into whether someone can get a certain case sealed or whether they're eligible to seal at all. It's good to break it down into these steps. So first you decide, is this person an eligible offender? And that's mostly just counting their convictions. And that is what really changed with the new code the new section that was added to the code. Next, you need to look at the person's convictions. Are these convictions things that are eligible to seal? There's a whole section of the code that lists things that are not eligible to be sealed at all, no matter what other cases the person has. And then the next thing to figure out is if this person has waited the appropriate amount of time. There are wait times which are different for felonies and misdemeanors, and you have to have waited that amount of time before you apply to seal that record. And then the last question you want to ask is, does this applicant have any pending criminal proceedings against him? Because if an applicant has pending criminal proceedings, he's not going to be able to get anything sealed. So the first step, there are two tracks that let someone be eligible. The track 2 is the old way. So under the old version of the law, you could have one felony and one misdemeanor, or 2 misdemeanors. And under that version, there were no requirements on like what the charges were, you just counted. That old version of the law is still on the books. So a person can be eligible under track 1, the new version, or track 2, or just one of those tracks. So it makes it a little complicated. The new version, track 1, is what lets people with more convictions seal. So it lets people with 5 or fewer felony convictions seal them as long as they were only F4s and F5s, and as long as none of those convictions were offenses of violence or felony sex offenses. So for this section, you not only have to count the convictions, you also have to look at what they are. Where under the old law, for this step, you just counted.
So what if you have misdemeanors as well? What if you have 5 felonies and some misdemeanors?
So there's no limit on the number of misdemeanors. So as long as you have less than 5 or less felonies, you can have an unlimited number of misdemeanors.
And do you get those sealed too? Or?
Yeah,
Okay.
you just have to apply in the court that convicted you to get a record sealed. So if you have like 4 felonies in common pleas court and then like 7 misdemeanors in municipal court, you can apply to get all of those sealed, depending on what they are. You just have to go to the separate courts. And you do look at a person's whole record, not just at the court they're applying to seal in. So if someone has a record from a different state that would make them that couldn't be sealed here, they're not going to be able to get their stuff sealed. So you look at the person's record as a whole, not just in the court they're trying to seal in. Okay, so the next question you want to ask is, are the convictions this person is trying to seal sealable offenses? So there's a section in the code, 295336, that is just a whole list of what cannot be sealed. The first thing on that list is convictions for 1st and 2nd degree felonies. This one kind of makes sense. You know, you're not going to want to let someone seal a, F2 felonious assault. So no 1st and 2nd degree felonies can be sealed at all. No convictions that carry mandatory prison time can be sealed. This next one is what trips a lot of people up. No convictions for traffic offenses can be sealed. So like OVIs, physical controls, those can't be sealed. We see people every day that come in, they're like, I want to seal my OVI. You can't. OVIs cannot be sealed. The next list of things that can't be sealed are sex offenses. So no, like rape, sexual battery, none of those things can be sealed. The next section of things that can't be sealed are offenses of violence. So this section of the code says that no felony or 1st degree misdemeanor offense of violence can be sealed. But this part of the code has an exception. Sorry, I'll let you guys find the slide I'm on. I feel like I'm going a little fast. This part of the code has an exception for riot, M1 assault, M1 inciting to violence, and M1 inducing panic. These offenses are sealable, even though they are technically offenses of violence. But the understanding in Franklin County courts right now is that even though these are sealable, they're still offenses of violence. So under the new track, where you have to look at whether anyone's been convicted of offense of violence, these things would still block those people. So if someone has one of these charges, even though it's sealable under this section, it wouldn't be sealable because they wouldn't be eligible to seal. So it's weird that a sealable offense would affect someone's eligibility, but that's how it's being read in at least our courts right now. So if someone had one of these charges, plus one other thing, they could get their thing sealed under the old track though. But if they have one of these plus two other things, then they wouldn't be eligible because they would have too many convictions under the old way and they would have an offensive violence under the new way. 2901019 has a list of all the things that are an offensive violence. So you don't just have to guess about what is or is not an offensive violence. And some crimes are tricky because, see down in the corner, some sections of crimes are offensive violence when the whole crime is not. So, for example, burglary. An F4 burglary is not an offensive violence, but any higher degree burglary is an offensive violence. So it really depends on like what part of the code someone was convicted of, whether their crime is sealable or not.
And we do have some larger print versions. If someone, because we have that list on your slides, I know it came out small.
Yeah.
If anyone wants a larger print version, we can provide that to you as well.
But it's like pulled right out of the code too, so. And also the offensive violence definition says that any attempt of an offensive violence is an offensive violence. And also any offense resulting in physical harm or the risk of serious physical harm is an offensive violence. So just because something isn't on this list doesn't mean it's not an offensive violence. This list is just a start.
Is that under just the new or the old as well?
That's under the definition of offensive violence. So our court right now is at least reading that as under just the new. Yeah.
But they're not sealable offenses under the old one, unless they're one of those exceptions we talked about on the last slide. And we'll do some examples at the end.
Yeah. The examples are what really helps
confusing.
it sink in. The last two sets of things that are not sealable are things that look at the age of the victim. So none of these things can be sealed if the victim was under 18. And then convictions for any felony or first degree misdemeanor can't be sealed if the victim was under 16, with the exception of non-support. So a lot of times you have to like go look at the complaint to see if how old the person was in these cases. Like we get a lot of people in who want to seal like they were buying alcohol for someone who was underage. So we're like, okay, well, how underage were they? Were they just under 21? Were they under 16? You know, you have to know the age of the victim to know if some of these crimes are sealable or not. This is the list of everything that can't be sealed. I just put it all into one slide. And then this code section is up in the top corner. So 295336 has this whole list in it and it explains all of these things. So if you have a question about whether something's sealable or not, that's the code section you want to look at. All right, the next question you want to ask, like I said earlier, is has this applicant waited the appropriate amount of time? You have to wait 3 years, 1 year after a conviction and a misdemeanor, 3 years for a felony, 4 years for 2 felonies, and 5 years if you have 3 to 5 felonies. And this part of the code says that if this person is applying under the new part of the law, which means they have more than 1 felony, they have to wait, in this section right here, they have to wait this time frame even if that's not the felony they're trying to get sealed. So normally, if you have someone who has 2 misdemeanors and they're only trying to get one of them sealed, they only need to wait the year on that one. It doesn't matter about the other one, as long as it's not pending anymore. But under this section, it says that if this person is eligible under A1A, which means the 5 or fewer felonies, this wait time includes all of their felonies, not just ones they're trying to get sealed. So this could affect someone who has like 2 felonies and one was really old but one's new. They have to wait 4 years from the new one. It doesn't matter that they've waited way more than 3 from the old one. So they have to wait 3 years, 1 year, whatever, from the final discharge in a case. And final discharge has been really defined in some appellate court cases. It's not just the disposition of a case. There's a lot more to it than that. So a person has to have completed any term of incarceration in a case, obviously, before they get a final discharge, completed any period of community control or post-release control, and they also have to have paid all of their fines and any court order restitution to get a final discharge in a case. But like it says at the bottom here, a sentence doesn't include payment of court costs, so they don't have to wait a year from when they finish paying their court costs. So if you have someone who owes a $100 fine still in a case and $200 in court costs, they're going to have to wait a year from when they pay that fine. But then during that year, they can pay the rest of those court costs off and apply as soon as those court costs are paid and that year has elapsed. So the fine is what makes them wait, not the costs. Okay. The last thing you want to make sure is that the applicant doesn't have any pending criminal proceedings against him. So this includes being on community control in any other case or owing a fine or cost in any other case. So you really want to make sure your clients don't pick up any like new traffic tickets when they're waiting to get their record sealed, because that could be a reason why the judge wouldn't seal their criminal case. Because they want to make sure they don't owe the court any money when they're trying to ask it for a favor, basically. There's this section of the code that never really gets brought up much, but it is related to record sealing, so I wanted to include it for you guys. The first part of this, section A, says that a defendant can't apply to seal dismissed charges if they're related to a conviction if they can't seal the conviction yet. So they have to wait to be able to seal a conviction. They have to wait to seal both, basically. So if someone gets picked up and they have two cases from the same incident and they plead to one and then they dismiss the other, they can't get that dismissed one sealed until they could get the conviction sealed because they're related. And they do check, so don't think you can just sneak it by because they'll find it. And then this bottom section says that if a defendant is convicted of one traffic offense that's not an OVI or physical control, and all other charges in the case were dismissed and are sealable under the dismissal statute, then they can apply to seal that whole case. So that's the only time you could ever seal a traffic case. And we don't really deal with this because people, like, a traffic case isn't people's issue. They think it is, but it's not. So people come in all the time and want to seal their traffic cases, and this isn't really, like, this is so in the weeds that it's not something we really ever deal with. So again, this is just those 4 steps again. First, you decide if they're eligible. You look under the 2 different tracks because they only have to be eligible under one of the tracks. So them being ineligible under one doesn't stop them. They just have to be eligible under one. And both tracks are on the books. And then you look at the convictions, make sure they're not on that list of things that can't be sealed, and then make sure they've waited the appropriate amount of time in each of their cases, and they have to wait until they've waited the longest amount of time possible. So if they're trying to seal like a misdemeanor they got 2 years ago and one they got last year, they're going to have to wait until a full year has passed from their latest conviction. And then you want to make sure they don't have any criminal proceedings against them. So some common problems with eligibility we see all the time are just that the applicant has too many convictions. This happened a lot more under the old law when you could only have 2. Now that you can have 5 felonies and unlimited number of misdemeanors, it's really hard for someone, well, I mean, it's not, but we see a lot less of people having too many convictions. What we see more now is that an applicant will have unsealable convictions, which means they have an offense of violence, which is going to block them from sealing all of their stuff. Another thing we see a lot is that an applicant hasn't complied with the statutory waiting period. So people will try to come in and seal their record while they're still on probation in a case. And you have to wait until you're done with that, and then wait a year before you can get your case sealed. So sometimes people get mad because they want to seal it while they're still on probation, and that's still a very active case, so they have to wait. Another issue we see a lot is that an applicant will have pending cases. So they'll have, like, just gotten picked up for a drug case in Lancaster. They can't seal their stuff up here while they still have that pending case there, or if it were here, doesn't matter. They can't have a pending case anywhere. The next issue we see a lot is the applicant's whole case isn't eligible for sealing. So a lot of times in a case, there'll be multiple charges. And so one charge in it will be eligible to seal, like a theft charge that they've waited the amount of time for. But then there'll be another charge in there for some kind of assault or something that can't be sealed, and they just want to seal part of the case, but you can't. The whole case has to be able to be sealed to seal any of it. The next thing we see a lot is people who want to come here to seal their records everywhere, but you can't. You have to go to the court that convicted you to be able to seal a record. So if you've got cases here and some in Lancaster and some in Delaware, you have to go to each of the courts to seal the records. And a lot of people have cases in mayor's court and they don't even really remember they have them or realize they have them, and then they try to come here to seal them, but the mayor's court has those records, so they need to go there. So really even just finding out where a person's cases are is the first step in all of this. The last issue we see sometimes is that an applicant is ineligible to seal due to convictions outside the jurisdiction. So if someone comes in and it looks like their cases here are sealable, like they just have one theft case here, great. But then they have a robbery charge from Chicago. They're not going to be able to seal that theft case because of that other charge that would make them ineligible because they have a conviction for an offense of violence. Well, that's not a good example because then they could still. They have two theft cases here. So you have to look at all of their convictions. And a lot of times people don't even remember what they have, so you can't always trust that they don't have something somewhere else. So that's something to think about too.
Before we move on, I know that was a lot. I know that's very confusing. Do people have questions before we move on to sealing dismissals? Yes, sir.
Yeah.
You've done a good job explaining the law. I'm under the impression that from the court's perspective, you don't exist. You're giving the forms out.
Yes.
So once you file this, what happens?
We help people look up their application. I'm going to go into the process of like everything that happens, but we look up people's eligibility. We'll tell them if they're eligible or not, help them with the application. They sign a limited scope agreement basically saying they understand that we're not their attorneys. We're providing them with just this one-time assistance with this one specific thing. They sign it at the end saying that they're doing this pro se. It goes off and they do the process on their own after that. If it gets into one of those issues where it's a little more weedy, like that second multiple convictions thing, that's when we'll refer them to legal aid. We'll refer them to a private attorney and tell them, you want someone going to court with you for your sealing hearing, because you need to make a legal argument that's more complicated than what we're able to explain to you right now on this day. So record sealing is the one area where the court's given us a little more leeway. They've said telling someone if they're eligible is really just looking at the statute and knowing how to read it. It's not really analyzing the statute, so the court doesn't see it as legal advice. That's about as close to the line of legal advice as we get, though, as looking up someone's record and figuring out if they're eligible, though. Does that answer your question?
That's consistent with what you said before. I'm curious what happens once you file.
Gotcha. So we'll get into that in just a minute. So let me get through dismissals and then we'll go through the whole process.
We've got
I have a quick question. Unrelated.
Yes.
Is there any way you can send an email, because some of these circles on here are dark?
Of course. Yeah.
Okay.
I'll have to get your email addresses. I don't know if you got them to Angela when you registered. If not, I'm happy to send out an email if anyone just leaves me their email address.
Yeah.
We'll leave a piece of paper
we're
for it.
registered.
Okay. I'll check with Angela then and I'll make sure we send out an email with the slides.
Okay.
Yes.
So just so that I'm sure I understand right, so you could have 5 felony 4s and 5s expunged, but if you have 1 misdemeanor assault on your record, none of that can be expunged.
Right, because that makes you ineligible under the new track.
Well, for sealing, yes. Expungement.
I'm sorry.
Yeah.
For
Okay.
Yeah.
Yeah. But if you had like that misdemeanors and assault, none of those felonies could be sealed. So, which drives a lot of people crazy and you get a lot of angry people at that point. But that's...
Especially because a lot of people will have pled to that assault thinking it was sealable. Because it is sealable, it's just something that can make them ineligible to seal. And people don't want to listen to that, especially because a lot of the PDs were, telling people like, assault, it's fine, like you can get it sealed. And you can if you don't have anything else, or you only have one other thing. So that's the thing that gets a lot of people riled up.
Yeah.
So plead to disorderly conduct because it can definitely be.
Okay, so luckily sealing dismissals is significantly easier. I'm going to spend maybe 5 minutes on this, if that. The short answer is a dismissed case can be sealed as soon as the case is over. We probably had 4 or 5 people in just this morning that their case got dismissed out of arraignment court, completely dismissed, not going anywhere after that, come straight down to our office, can seal that same day. And Franklin County, apply to seal it, yeah. It still takes about 8 to 10 weeks to do the application through the process that we'll be talking about. But they can apply immediately after the judge makes that decision. Sealing dismissals is free, whereas sealing convictions is $50. I'll get into that in a minute. But basically, the second your case is dismissed, you can file that application. As I said, most important thing to remember, no wait time for dismissals. If it's a no bill, there is a 2-year wait period. But that's pretty much all there is to sealing a dismissal or a no bill. Either if it's a complete dismissal, no wait time. If it's a no bill, just wait the 2 years and then you're good to go there. So here's the question that you were asking me about the process. So first step, come into our office or talk to one of you, figure out if they're eligible, and then file the sealing application with the court of record. And that's exactly what we've been saying over and over again. If you've got felonies and misdemeanors, you're going to be filing in both common pleas and municipal court. If you've got something in Chicago, you're going to have to file under their law. If you've got something in Cincinnati, you're going to have to file down in Cincinnati. After that, no matter where it is, as long as it's in Ohio, the probation department for that court performs a background check. We tell people if you've got a parking ticket in Utah, they're going to find it. So there's no trying to hide anything from that background check. That background check finds everything in every state, and that's why it's important to ask people, not only do you have anything else, but where have you lived in the past, so that if you think someone's forgetting about something, you can go look it up yourself. From there, that whole report goes to the prosecutor. The prosecutor has an opportunity to file an objection. That objection can either be this person's not eligible, or we have some policy reason why this person shouldn't be allowed to seal their record. One example that we see of a policy objection is if someone's been charged with domestic violence 5 times, and every single time it got pled to a disorderly conduct or it got dismissed, the prosecutor could still make the argument saying, this person, for all we know, has done these things. Just because it was dismissed or it pled down doesn't mean that they're not a dangerous person or that they're a violent person. We want to keep those records open to the public because we think the public has an interest in knowing these. From there, it goes to a hearing in front of the judge. The judge does have discretion as to whether to hold a hearing or not, but generally most things go to a hearing, and especially in municipal court with 15 judges, I don't know what gets decided for a hearing and what doesn't. It varies by judge. It varies on the day. So never tell someone like, oh, don't worry about this, there's not going to be a hearing. I've seen hearings on 1 dismissal. I've seen hearings on thousands of cases, or 5 or 6 cases is more realistic. At that hearing, the judge weighs the public's interest in keeping that record open versus the individual's interest in having it sealed. So even if a person's eligible under everything else we've talked about, the judge could still decide at the end of the day, no, I don't want to seal your 36 misdemeanor cases. Yes, you're eligible under the law, but I think the public has an interest in knowing that at some point in your life, you've been charged with 36 different misdemeanors. So that's one of the big changes with this new law, is that it just gives a lot more discretion to the judges to make that decision. So if the applicant's record is sealed, they do then get a letter in the mail saying that it's been sealed. They definitely need to keep that letter. That's very important. Because from there, there's all of those third-party background search companies on the internet. They're supposed to update their records right away. The reality is that they don't do that. A lot of times those companies only update their records with the court once a year or once every other year. So it's very possible that even though you got this stuff sealed, you're not going to be able to get a job because it's still going to keep showing up on those background checks. If that becomes an issue, someone applies for a job, they say, no, we don't want to offer you this job because this shows up on your background. They need to go to that employer, ask what background check company they used, get a copy of that background check, and then contact that background check company with a letter that includes a copy of that notice that they got that it was being sealed, saying, this has been removed from the record. You need to remove this from your records as soon as possible. If they don't do that, they need to contact the Ohio Attorney General immediately. The Attorney General has a whole office that just does this type of work. And there are some penalties under the law for companies that don't remove the records in a timely manner. That's often a big problem we see, though, is that there's no real set in stone way to remove these off of the internet. So people have to be a little vigilant about it. There was a pilot program about 6 months ago or so that lost funding. So unfortunately now that doesn't exist. That pilot program had an automated way that people could pay an additional fee to the court, and the court would ensure through using an outside law firm that it got scrubbed off the internet. Since that doesn't exist anymore, people just have to do it on their own. So that's often a holdup, and that's an important thing to know to tell your clients. So to move on from, I'm sorry.
Do prospective employers have an obligation to give a copy of that report?
Yes, yeah. So if that's their reason for not offering them the job, yes.
Have you seen any examples of, under the new or the old law recently, of a judge using that discretion to decline to offer someone sealing?
I can't think of a specific example off the top of my head. Our challenge is after we help them with the record, we don't often follow up.
Sure.
So I don't always know, like, if someone's come into our office, I have seen a lot of those policy objections saying, you've got 5 domestic violences that pled down to something. And I know judges in the past have granted that, as saying they will seal that or they'll not. Honestly, a lot of times it takes the luck of the draw of what judge you get at that case. And that's when it's really the onus of the applicant to come in and say, this is exactly why I want this to be sealed. So examples of good reasons we've seen people give is obviously jobs, obviously better apartments. We had a father come in that got his record sealed that said, I took my daughter to a play date. When we got there, the other parents said, they don't want my daughter at the play date because they did a background check on me. And because I have a record, it's now hurting my daughter. We had another father that wanted to coach Pee Wee football and couldn't do it because of his record. So just jobs aren't the only reason that a judge is going to do it. They just need to be as honest as possible and give every reason they can think of.
Because there's a spot on the application for the person to write why they want the record sealed. So the better reason they have, and the better reason they can say in their hearing as to, this is how my record has affected me. Like, I didn't get this job because of it. Like, this reason with my kid. Like, I want to move, and where I want to move doesn't let you live there if you have a record. The more reasons they have will, like, weigh in their favor more.
Yeah.
Especially when it comes to, like, policy objections from the prosecutor.
So while we don't have a specific example, it's definitely possible, and I've definitely heard of it happening, even if I can't think of a specific example right now. Any other questions before we move on to CQEs? Last topic we're going to cover today is one other option for people who have criminal records. It's called a Certificate of Qualification for Employment, which is a mouthful, so I'm just going to call it a CQE. That's what most people around the state call it. So if you hear those letters, that's what we're talking about. So how we explain to a CQE is it's an open window when the door has been slammed in your face. Most of the time, it's to lift the mandatory collateral sanctions around having some kind of licensure. One example that has always blown my mind is you cannot get a barber's license if you've been charged with fraud. I don't know how fraud affects your ability to cut someone's hair, but that's something that Ohio law says that if you've been charged with fraud, can't be a barber. Can't be considered for the job, can't be considered for the license, just hard stop, no. A CQE says you may not be able to seal that fraud, but even though that fraud's not going to be sealed, the judge is saying you've been rehabilitated and you should be allowed to be considered for those jobs anyway. So especially for people that aren't eligible to seal their record, and if they have something like a barber's license, home health care worker is a common one, most things that have some kind of licensure. There's even things with like horse husbandry that you can't breed horses if you've had certain things. So there's a whole list. There's a website that we'll get to in a minute that you can look at that whole list. This is kind of another option that at least gives people a chance to try. Now, the question we often get is, well, why would an employer want to hire me if they know that normally they wouldn't be allowed to with this record? It does provide some benefits to the employer. The first one, it lets them hire basically anyone they want. It lets them have a better choice of who their applicants are. The other one, and the more important one, is it gives them protection from negligent hiring liability. So an employer that hires someone with a CQE, if that person then goes and makes a mistake, that employer has protection saying, no, I didn't think they were going to do this bad thing that they did. because when I hired them, the court had said they'd been rehabilitated. The court gave them the CQE. So to be eligible, there are certain caveats with everything else. Sex offenses still can't be helped with a CQE. You can't get a CQE and magically not have to be on the sex registry. Just any sex offenses can't be applied to a CQE. It doesn't apply to driver's license, and there are some exceptions for healthcare workers and law enforcement officers, especially healthcare workers when the original offense was a possession of drug offense, especially as it applies to opiates, and then wanting to work in a medical center that administers those types of drugs. So just because you have a CQE doesn't mean you can go work at a hospital that might give someone high-level pain medicine. The timing's a little shorter. For felonies, it is only 1 year. For misdemeanors, it's 6 months. So often someone who is not even eligible to seal yet because of the time might still be able to get a CQE to start getting their life back on track. And that's the goal with a CQE. Application process is very similar to what it is for sealing records. First part, you have to identify the specific barriers. That's on this website right here. This DRC CQE has the application as long as a list of all the specific collateral consequences. So you can go on that website and search by, I have a fraud on my record, or I have a possession of drugs. Or you can say, I want to be a barber, I want to be a nurse, I want to be this. And it'll either give you the list of jobs that you're blocked from based on your record, or the kinds of things that are on your record that you can't do because of the type of job you want. From there, the record submitted to ODRC, the Department of Rehabilitation and Corrections, they do the review, whereas for sealing records, the probation office does the review. ODRC basically gives a printout of the application and either approves it or denies it. If it's approved, the applicant has to then print out that application and take it to the common pleas court in the county that they live. This isn't necessarily the county where they hold the record, it's the county they live now. From there, the judge, much like in a sealing record, can decide to hold a hearing or not. At that hearing, the judge is going to decide the same type of thing. What's the interest in having this person have a CQE? What's the public's interest in them not having it? And the other big question for this one is, does the judge believe this person's been rehabilitated? From there, the petition's either granted and they need to print the certificate from the portal, or it's denied and they can make a appeal to that, but that's very limited appeals there. So this is a lot of the same things. Before that hearing, the court does do its own investigation, just like with a sealing record. Prosecutor can object if they decide, no, I don't want someone with this charge to have a CQE, and then the hearing goes a lot the same way. The court does have to make a decision within 60 days, and here's the different standards that they use to see that. Common problems are you haven't waited enough time, it's not an applicable offense like we talked about earlier, or the type of offense like a sex offense or a crime of violence is one that a CQE doesn't cover. So those are pretty standard, but those are the ones that you see as the common problems of someone wants to get a CQE but they can't. As I said before, these are the different ways you can use a CQE. I've seen people use them in creative ways as well. We had someone come in that had a CQE for his job, but his record was also keeping him from being able to get housing. He took that CQE to the potential landlord, said, look, the court says I've been rehabilitated. Will you use this as something to consider as a positive when considering my rental application? And that landlord happened to do it. That's not a guarantee that every landlord would, but I have seen people use CQEs in kind of that way that not everyone does. The big challenge here in Franklin County with CQEs, though, is that not a lot of employers understand the benefits for them. The largest number of CQEs is currently up in the Akron area. That's because Akron Law School worked with some big companies like Goodyear to explain to them the benefit of CQEs, and now companies like that specifically hire people with CQEs. There isn't a program like that here in Columbus, so just to be on my own little stump, anytime you're talking to employers, anytime you're talking to someone that you know works with people that have some kind of licensure, mention CQEs to them, mention the benefits that they have. I'm always happy to go out and talk to employers. If more employers knew about this would help significantly more people here in Franklin County. So to get off my stump and to go back to what we're actually talking about, ways that CQE holders or employers can lose the benefits, holders charged with a felony, or somehow the holder has demonstrated dangerous behavior. That's a pretty general term. Just if they've done something that shows that they could be dangerous, they could possibly lose their CQE benefits. Employer can lose it basically if they have knowledge that the employee is somehow dangerous, or that they know for a fact that that employee has pleaded guilty to a felony. So just because the employee has pleaded guilty to a felony, if the employer for whatever reason doesn't know about that for some strange reason, that possibly would not be enough to have them lose those benefits, especially that negligent hiring liability. Questions about that?
Did that change with the new law?
That did not. There's been some talk about changing CQEs, mostly removing the requirement to actually identify a collateral consequence, which would really open up CQEs to allow anyone that can't seal their record to get one, and not make it tied to having a licensure. But that hasn't passed through the legislature yet. It's been proposed multiple times, and it just hasn't gone anywhere. So I'd love for that to happen, but it hasn't happened yet. So we did promise to go through some examples. So we're going to go through some examples of some records, see if they're sealable or not. Shout out the answer. I'm not going to call on anyone, but first example here, and I don't know if you want to jump up and do some of these. This person has a felonious assault from 2011, released from prison in 2015, and they were given a 5-year period of post-release control upon release. This is the only thing on their record. As of today, if they came in and talked to one of us, would they be eligible to seal their record? Right, because it's a first-degree felony, also because felonious assault is an offense of violence, and because their 3 years hasn't expired. So they have multiple reasons why they can't seal this record yet.
So some reasons a person can't seal a record are going to be a bar forever. Like that record's never going to be able to get sealed, like something like this. But other people have like curable reasons why they can't seal, like they just haven't waited the time or something. So sometimes when you're explaining to a person whether their record can be sealed or not, it's like a hard no, and sometimes it's just like, no, you can, you just have to like wait a little bit longer. Or no, you can, but you have to pay this first. So figuring out whether someone, it's always going to be a no, or whether it's just a no right now is really important to these people too.
But the turning down of a time period, they don't hold the application, he must refile, right?
Yeah.
Right. Often what happens is the judge will ask them to withdraw their application, and then they need to refile. Because there's a big question of, if the judge denies it, if they can reapply. So if someone's ineligible, it gets to court and it's getting close to the judge making a decision. Oftentimes, if the judge is being nice, he's going to say, hey, you should withdraw this, come back and talk to me again in so many months.
Or if he's being really nice, he'll continue their hearing for a couple months until
Right.
they are eligible.
We often see that as well. And often what judges will say is, I can't tell you why I'm continuing it. Go down to the 6th floor to talk to the Self-Help Center, and they'll explain it to you. So we see people at that point in the process as well. So next example, dismissed F1 felonious assault from 2010. That's the only thing on the record. Are they eligible to seal? Yes, because it's a dismissed case.
And dismissals aren't affected by the list of things that can't be sealed. So any dismissed case can be sealed, no matter whether it's on that list or not. Now they have a dismissed case, but it's from this year. Can that be sealed? Yeah.
Yeah, because like I said before, no wait time for dismissed cases. So a no-billed F1 felonious assault from 2019. Right, they're going to have to wait until 2021, if my math's correct, to get that one sealed. M4 disorderly conduct from 2010. They paid all their fines and costs in 2013. There's nothing else on their record. Yeah, that one's eligible under both Track 1 and Track 2. So even before the law changed, they could have gotten theirs sealed. What about if we add an M1 theft that they paid their fines and costs for in 2016?
They paid in 16.
In 16.
Yeah.
And it's a misdemeanor. So the wait time for misdemeanors is just 1 year, so their wait time would have been up already
Doesn't matter how many misdemeanors you have. If all you have on your record is misdemeanors, you only have to wait a year.
from the last one.
Right. Okay. Add one more theft to that. This one they also paid in 2016. Yeah. This one they can only apply under the new law. They're not eligible under the old law. And it's the same application. It doesn't matter to the applicants which way they're filing under. But just so you kind of can see the two different ways.
So before November, this person wouldn't be able to seal anything because they had more than 2 convictions.
Okay. What about if we add one more theft, but they paid their fines and costs for this last one in 2019? Right. They haven't done the waiting period. However, he can seal the other 3 because he has waited the year on those. So had one of these been a felony, he would have had to wait 3 years from like that 2016 date, but since they're all misdemeanors, he's done his waiting period. Okay. What if we change that last assault or that last theft to an assault that they paid in 2016? No, because that assault is an offense of violence. So we're going to change it. He just has one M1 assault that he's paid in 2016. Is that eligible? This one's a trick, and this is what we were talking about earlier. This one he is, yes, because assault, that M1 assault's an exception under the old track, but not under the new one. So because he has 2 or less, he can seal that assault. Does that make sense? I know this is where it gets really confusing. This is why we want to do some examples.
And it's not just assault. There are those other exceptions too. And there's a lot of misdemeanors that are offenses of violence that aren't on that exception list. Like menacing is an offense of violence. So that can block people too. So that offense of violence list itself doesn't have any exceptions for the degree of the charge. Well, except at the end, but.
Okay, so what if we add an M3 criminal mischief to his record? So that one, he's still under the old track, track 2, because he has 2 or less. However, now we've added a third theft. Is he eligible to seal his entire record now? Right. This one's a no. Now that assault comes into play, and now he has an offense of violence that stops him from being able to seal his record. So as long as you've got 2 or less, if you've got one of those exceptions, you can seal it. If you've got more than that, you can't seal it. Okay. Now we have someone with an M1 domestic violence and an M3 criminal mischief. This one gets a little tricky. They can seal the criminal mischief. They cannot seal the domestic violence. Domestic violence is a crime of violence, but because he has 2 or less, that's not a bar from sealing his entire application. So he can do the criminal mischief still, as long as, go ahead.
He's eligible under the old version of the law. It's just that his domestic violence is a unsealable offense.
Okay. Now what can this person do? M1 domestic violence, M3 criminal mischief, M3 theft, and a dismissed theft. We only got a couple minutes, so the dismissed theft can be sealed. Dismissed cases can always be sealed. Don't even have to look at the eligibility for anything else. But because of that domestic violence, none of his convictions can be sealed. Often for people, at least getting something off their record's better than nothing. So we will help people with their dismissed cases, even if that's all they're getting off their record.
But if this person put all of these things on an application, the judge would have to deny it because the judges have to approve or deny a whole application. They can't pick and choose which cases within that they're going to seal. So this person, if a person is like this where they can only seal their dismissals, we need to make sure they're only trying to seal their dismissals, because if they try to seal the other ones too, the judge is going to have to say no to all of it.
Right.
Not to try again.
This one, you've got 2 OVIs. Not sealable. OVIs aren't sealable. I'm going to skip this one because we're running out of time.
Okay.
Basically, this one is the theft can be sealed, but the OVI can't. Under that old track, the track 2 that we're talking about, if you've got someone, say you added an assault in here, those OVIs count towards your limit of 2, which I guess is actually our next example. So OVIs count towards your limit of 2 in the old track. So if all they have is an assault plus 2 OVIs, that's going to make them ineligible to seal that assault.
And that comes up all the time.
Yeah.
People always have OVIs.
So if you're looking for, if you see an assault, you need to start looking at every traffic case. You need to start looking at everything on someone's record to figure out exactly what's going on there. Okay. However, if this person wants to be a home health care worker, they may be able to apply for a CQE because an assault is a block from being a home health care worker, and that's not one of the crimes of violence that blocks someone from getting a CQE. This one, M4 conviction, but they still owe $400 in restitution. As we were saying, they haven't reached final discharge because they haven't paid that restitution. As soon as they pay that $400 restitution, they can seal the rest of it. Oh, did I?
It's just the next one.
Okay.
So if they paid off their restitution today, they could apply to seal a year from today.
Let's get to the expungement one, and then.
Yeah.
So we're going to skip a couple of these just
Well,
because.
these are getting to expungement.
Okay. So you're going to see a couple examples here of just things that can possibly be sealed or not. You'll see the answers go through. We just want to use an example of an expungement too. So that's their record. They can apply for an expungement even if they're not eligible for a sealing, as long as they can prove that they're a victim of human trafficking. And as I mentioned earlier, along with the loitering, this drug paraphernalia is a really strong sign that someone might be a victim. That is a very difficult conversation to have someone, but if you're looking at someone's record and see that, it is an important one to have. So I know we're at our time limit, so I'm happy to answer any other questions, but I do thank all of you for coming out today. I do really appreciate it. And if anytime we can ever be of assistance, our email address is there, or I can give you my card. Please don't share our email address with clients. The court only lets us help people if they walk into our office. We can't provide any services at all by email or phone. So, thank you.